call the meeting to order. Council in Committee, January 27th. I ask for a disclosure of pecuniary interests from Council. Seeing none, we'll go to the adoption of the agenda. Moved by Dave McCoy, seconded by Charlene Jackson. Be resolved that the Council in Committee adopts the agenda for the meeting of January 27, 2016. All those in favor? Opposed, if any? Carried. I will at this time turn the meeting over to Brian Whitehead and Mr. Cheeseman, and I have to get a Mr. in there somewhere, right?
Thank you, Mr. Mayor.
If you could just give us about 1 minute to relocate. We have a great setup here, but it's not always great for the people sitting at this desk.
Thank you, Mayor Johnson and members of committee. I'm Charles Cheeseman, Manager of Planning Services for the County of Renfrew, and Mr. Whitehead is here from JP2G Consultants. He and I will share the presentation tonight. Brian was present at the creation of Official Plan Amendment number 11, very familiar with the process. I was involved in the process as it came to the county and movement to the province for approval, so I've got some background on that. And between us, we have a pretty good handle on the situation. We have 17 slides tonight on our PowerPoint presentation, and Brian and I felt that we would take questions as we go through the presentation. So if there's a slide you want to talk about or something, just raise it at that point, and that would be the best way to deal with that. As far as the materials that you were given, there was a letter from Mr. Whitehead, a cover letter to the package outlining recommendations and planning comments. There was a letter from the province, which was their draft decision on Official Plan Amendment number 11. There is the PowerPoint presentation, and the other document is what we've called Official Plan Amendment number 11, bold and strike-through version. This document here, and it should be all on your, I might suggest you put this on your computers if that's possible. The reason I would say that is that if you could follow the PowerPoint presentation on the big screen, and Brian might be referring to this document as we go through, and it could be, if you don't have it available, that's fine, we can still look at it, but if you do have it on your computer screen, that would be great. This bold and strike-through version, sure.
That's the third item in your package. You'll see it's got the yellow and red strike-throughs.
Sorry, Mr. Mayor. Thank you very much. Yes, I'm going to do that right now. So that bold and strike-through version, what we did is we took as the mayor's getting ready, we took the draft decision of the minister and married it up with the actual amendment, so you can see the changes that the province is proposing right in the context of the policy. And so in that document, the text that the province wants to add to OPA 11 is highlighted in yellow, and in red deleted text is things they'd like to take out of OPA 11. And there's also in the side margin of the document, you'll see in about page 4, starting around page 5, I believe, or page 4, there is a number in the side margin, 1A, 2A, 2B, the far left side of the margin. Those are the actual minister's modification, so we can connect the minister's modification to the changes in the document, and hopefully this will flow as we go through the process. Just as a bit of a recap, then we'll get into the presentation. Official plans contain policies that deal with the development of land, matters on how land is divided up, policies for development around water bodies and protection of water bodies, the protection policies for resources like mineral aggregate and agriculture, planning itself, in a general term, is arranging things for the future. And planning as it applies to land is arranging the land for the future. So with that in mind, I hope that helped a little bit. It's what the land is going to be used for in the future. And one other thing I wanted to just mention is the provincial role in planning, and this will come up a number of times tonight. One of the biggest changes in my career, 25, 30 years in planning, is the enhanced role of the province in local planning. And they've set out through their provincial policy statements their interest in planning and what they consider provincial policy. And we are obligated under the Planning Act to be consistent with those policies. So years ago, official plans were more sort of a lot of community policies in it, and then over time the province is using them as vehicles for provincial policies, and you'll see some of that tonight as well. But that is the reality we're up against, and it's I just wanted to make you aware of that. That's the hierarchy of planning in Ontario. Yes, sir.
Charles, in regard to the provincial policy statement, could you explain to us here how that could be just a statement and why it would not be legislation? And what the difference is and why we're obligated to something that's never been legislated?
Thank you. The question is under, I believe it's Section 3 of the Planning Act, which is legislation. There's reference to the provincial policy statement, and in that section or somewhere close to it, it says all decisions must be consistent with the provincial policy statement, which is embedded in the Planning Act. And I can get the actual reference to you at a later date if you wish, but that's where that emanates from. So thank you. So with respect to tonight, I'm going to present some recommendations, and it's being presented to you for information to mull over. And we realize that the township, you have to sign off on this document, and you have to be comfortable with the policies for your township. It's your future, and so we're presenting our information to you, but ultimately it's, you can direct us what you would like us to do, and we'll give you some options at the end of the evening, but we're here to give you information, but ultimately it's your decision. So I'll start into the presentation. This is just a bit of background to where we've been. Official Plan Amendment number 11 is what it is Amendment number 11 to the County of Renfrew official plan that applies to the Township of Whitewater region only. So we have an official plan at the county level, and there's been about 27, 28 amendments to it over the years, and number 11 is the amendment that was made or proposed to be made to it by a document through Whitewater region to make changes to the county plan that were for Whitewater region only. And what that amendment number 11 did was add a new section, or proposes it to add a new section to the County of Renfrew official plan called Township of Whitewater Region Special Policies. And that is the beast that we also call Official Plan Amendment number 11. Township of Whitewater Region Council recommended by resolution dated July 16th, 2014, that the County of Renfrew Council adopt OPA number 11. And this follows a number of years, as you know, of work on that document. But July 16th, they sent a resolution to the county because it's an amendment to the county plan, it has to be adopted at County Council, that the resolution from the township requesting the county to adopt OPA 11 to the County of Renfrew official plan. County Council duly adopted that document on August 27th, 2014. And we forwarded it to the Ministry of Municipal Affairs and Housing, MMAH, for approval. The province is the approval for this document. The ministry reviewed and sent a draft decision to the county on September 3rd, 2015, which is one of the documents you have tonight, and that lays out, well, the next bullet. That's their draft decision. This is a draft that they sent to us to consider. Approving OPA number 11, but subject to certain modifications. And that is the official term for ministry proposed changes. They would like to modify the original official plan amendment number 11, and that's why we refer to their word changes as modifications. And I think Brian's going to talk to this slide. Right there. Thank you.
Charles has the touch. So from the outset of this from the outset, there were some very clear guiding principles or directions that were given to myself as a consultant. Incidentally, it was 10 years ago this month that the terms of reference was approved for embarking on a new official plan for Whitewater, an official plan review process. But at the core of that process, there was a really strong desire for growth and development in the municipality. That was the driving force at the time. There had been some incidents in the community that occurred, and one of them was, I think, the closure of the Ross Mindview School, and people were concerned about, employment and keeping young people in the community, and how can we generate growth and development, and a lot of concerns that many parts of rural Ontario have. Another element that evolved out of that guiding principle was to have greater control over decision making at the local level. And of course, since then, there was a 2005 provincial policy statement, 2014 provincial policy statement. So there's been a couple of iterations, and by January of 2006, we hadn't really digested the 2005 provincial policy statement, and that was the transition between shall we have regard to and be consistent with. In fact, the evolution of the 2005 policy statement has taken many years. And thirdly, as the project evolved, obviously the whole Muskrat Lake situation evolved as one of the most important issues of this official plan review. So that's it. So just moving on, there's just some examples of how growth and development's been incorporated into OPA 11. What it does is it creates a waterfront designation around all the major water bodies in the municipality, and to encourage and permit uses which are geared to waterfront residential, tourist, commercial uses, and existing agricultural uses. And really, when it comes down to it, first thing that we looked at is what is the township's major assets to attract growth and development, and we came up with three. And they're not all listed here, but certainly your waterfront, or our waterfront, is very attractive and valuable resource for development purposes. There's still large areas of waterfront that are undeveloped, and so consistent with that, we developed a series of concepts for waterfront development that I'll show you in a minute. Two of them actually are rather new and not actually implemented anywhere else. One is backlot development along the waterfront, and I'll get into that a little bit more. But backlot development mostly is discouraged in many waterfront cottage areas, but in where it is permitted, normally it's a large acreage that's required, like 10 acres, and frontage on a public road. So what we've been successful in doing, and what the province has accepted, is smaller backlots of a 1 hectare on private roads. And once again, I'll describe that a bit more in an upcoming slide. The other is the concept of rural cluster development serviced by a right-of-way. Rather than having, where somebody have 2 and 3 severances along an existing township road or a county road, why not have a small cluster where you have 3 to 5 units that have a long driveway, and it's wooded along the road. So you have these small clusters there where people can enjoy, the benefits of living in a rural area, but you're not, affecting the character of the municipality by having strip development along every road like you do along some areas not so far, like the B line. And of course, third one is we'll get into this a little bit more, is the creation of new lots on Muskrat Lake subject to a water quality assessment. And what I want to stress there is water quality assessment is not a study. But once again, I'll explain that when we get to the section on that. It's actually a site plan that would be prepared, but it's not a study. But I'll get into that more later. Consistent with so waterfront is mostly here, but there's 2 other areas where we identified where there's opportunities for growth and development. The other is the village communities of Cobden and Beachburg. Beachburg has been very successful over the last decade or more in attracting growth and development. Cobden not so much, but now there's interest in developing Cobden. And so the growth areas that you have available to you are Cobden, Beachburg, your waterfront, and your rural areas. Those are areas where we got the cluster development option in the rural areas, plus other regular severances, waterfront, and your small urban areas. Whereas areas you don't have development opportunities are your aggregate resources, the mine designation, agricultural areas, provincially significant wetlands, which, when you add them all into the mix, adds up to about 70% of your land area. So that's all I'll say about that. These are we'll have a series of 5 development concepts for waterfront development. This is the traditional concept of linear development along the waterfront. This is an actual location in Whitewater, but I won't tell you where it is. Anyway, it's your standard waterfront residential development with a private road or a public road. And just on that point, I can say that the province is not. When we met twice with the Ministry of Municipal Affairs over the past year and a half on the draft amendment, and they were very much opposed to any development on private roads, and as they have been in other parts of Eastern Ontario and Central Ontario, and for example, Lanark Highlands has appealed some modifications to the Ontario Municipal Board on that very topic. Rural Ontario likes to be able to accommodate development on private roads and waterfront areas. They backed off on that whole issue. So anywhere where we show you a waterfront designation on the official plan map, these development concepts can occur on private roads or public roads, with the exception of the rural cluster, or not the rural cluster, what is it? Yeah, it is a waterfront cluster. Maybe the next one, Charles. This is an example of backlot development, and it's got the traditional waterfront lots, linear fashion along the shoreline, with 3 backlots on a public road as one option, and then 1 lot that's on a public road leading to the public road, if indeed this development is a public road. Okay. This is a backlot development by private road. Same idea, except in this case, the principle is that for every backlot that gets created, there should be legal access to the water. So it's called a common access lot or block. And so in this case, we've illustrated 3 backlots. The minimum size of the backlots has to be 1 hectare. They have to have 60 meters of frontage on a public road, private road, but they can have access as long as they have access to water. Normally it's 20 meters per lot, but it's not exactly specified in the plan. And my rule of thumb with this type of concept is that the waterfront needs to be appropriate for the intended use. So if there's a proposal and for 3 lots, then you have to look at the access that's being provided and feel comfortable that it's appropriate for the circumstances. Go ahead. This is the waterfront cluster. This is like a little potential retirement community type concept. Again, it's a similar concept as the backlot concept, but just a larger amount of common area along the shoreline because of a larger cluster in the back. And in this case, there's quite a few more guidelines. This would be a plan of subdivision or a condominium approval for this type of development, given the scale. Okay. Go back.
What's the separation or setback from the shoreline to that public road that isn't developed only in the one spot? What's that proposal?
not sure I understand where,
Well, where we have, right there, what would be the distance required as a setback from there to that road allowance?
setback from water?
Yes, sorry.
Well, originally it was 20 meters, the ministry's asking for 30 for a water setback.
Okay, I got mixed up with the 20 meters off, we were talking width.
Oh, width, 45 meters for waterfront.
Okay. For the width of that,
Yeah.
that access.
Yeah.
So that access would.
Oh, the access, or like the...
I got two questions. Setback from the water, so we're looking at, from the water to the, edge of the road.
That's
There,
really a lot
there.
line, that's not a setback.
Okay, so those are lots.
Those are lots, yeah.
Okay, that's the
Yeah.
part that I was being confused with. So those lots are acceptable then?
Oh, yeah, yeah.
Okay,
That's the same waterfront concept
okay.
as
That
the
clears
original
that
one.
up for me.
Yeah.
Thanks.
Yeah.
You have, 30 here, you asked for 20, you got 30. That's correct? Asked for 20, got for 30.
Yeah, that's coming up, that's an item
Okay.
on the agenda,
Does
but
this
yeah.
buffer discussion in here come into play here?
Well, there's two concepts. There's a setback, and a setback is for buildings and structures and septic systems. And then a buffer area is an area that would correspond with that, and it should be, the idea is to protect it as a natural vegetative.
That's how big, 20 meter?
That's what's proposed, yes.
So that means nothing can be touched from the shoreline back 20 meters on all of these things that we're discussing, or partial things?
Well, that's the intention. It doesn't mean you can't, have an access to water or a pathway to the water.
Dock?
Or docks, yeah, you can have docks, or you can have, limbing of trees and removing of dead trees. The intent is to maintain it substantially in a natural vegetated state. And the reason for that is surface drainage. It's surface drainage is the shoreline of any water body is considered to be the ribbon of life, and it's where the most natural activity occurs in any water body. And if by having the vegetative buffer, it minimizes the overland flow of sediments that can affect habitat.
So that would be similar to having a buffer other places to prevent nutrients from getting in Muskrat Lake. It'd be same theory, right?
Absolutely.
Natural
Absolutely.
filtration.
It applies to agriculture. It
Okay,
applies
just to be clear.
Same principle, yeah. Although in agriculture, it's not quite as much.
And you have to forgive me because this is kind of new to me. To clarify from my questioning, the 20 meters, you can put a building, and you can cut the lawn to all the way to the water, correct? Around the trees and whatever, because that's still a buffer zone, if you will, or a setback. You can cut the lawn to the shoreline.
Well, if a new project gets approved, it would get approved with a condition saying, no, you wouldn't be able to
Cut the lawn.
cut the lawn to the shoreline. That's right.
Wow.
You'd have to enter into an agreement with the municipality that would be registered on the title.
That they could cut a lawn.
That would have a provision in it identifying the shoreline.
And you do know we would grant that immediately, right?
I'm not talking about enforcement. I'm just saying.
No, it's just what I'm looking at is this is a requirement of province, correct? This is a requirement of province. Am I not correct?
Well, the 30-meter setback is something they're not going to back down on. That's right.
Okay.
And if you want to
It
challenge it, what I can tell you, if you're not, the option available is you could say, no, we want 20 meters. We want to keep the 20 meters, and sort of force the issue with the province if that's what you want. Go ahead.
Correct me if I'm wrong, Mayor Johnson, but I think his question is, you want to put in a vegetation buffer for 20 meters. The question is, did the province demand that, or did the planners that Whitewater hired put it in the plan? That's the question.
Well, no, what we put in the plan was 20 meters.
Was
The
it
province?
required by the province to do that, is my question?
No.
Then why would we put that in there, is my question. It's hindering this.
What's it hindering?
Well, people don't want it.
They
Why would we, if we're pro-development, why are we putting things in the plan? Like, it's bad enough to follow provincial policy. My question is, why are we adding to it when it might not be necessary? Is there an environmental thing here that I'm missing, or?
Well, yeah.
Yeah, but then why isn't the provincial policy statement saying we have to do it? If they're not, and why are we doing it if they're not demanding it? That's my question. We're doing something that we're not demanded to do.
I'll try to answer that.
Okay.
And the provincial policy statement does contain policies about reducing the adverse negative impacts of development on water courses and heritage features. One way of doing that, which is a way that's used in many parts of the province, is a buffer area between the developed part of a lot and the water body, and that buffer is to protect the water quality and the runoff from the developed part of the lot. And it's good planning, and it's one of the environmental assistance to protect water quality. So you get your cake and eat it too. It may not, you can have development, but there is this buffer that's intended to help protect the water body that you're building around, so that you achieve both goals.
And this recommendation isn't just from me or Charles. It's also in the Mikowski recommendations. There's two ways that phosphorus gets into our lakes and streams. One is through the ground, and one is over the surface. Then Mikowski is saying if you maintain a 20-meter vegetated buffer, then any surface transfer of phosphorus into a water body, it's sufficient to mitigate that. So
Okay.
it's based on science, and it's considered to be good planning. It may not be considered to be good by a property owner or property rights, or there's going to be challenges in implementation and education and understanding, but it is good planning.
Okay, thank you.
I guess I have a question. Number one, they're probably looking for something in writing that states all of that. And number two, what phosphorus on a normal lot with grass fronting onto a waterfront property is going to be created? I don't understand the science of it all, so perhaps you can explain to it. I know it's good. You're saying it's good planning decisions to make sure that there is something that restrains, but if you're building back and your septic is good and everything else, I mean, there's a lot of properties on the Muskrat Lake, for instance, that do cut the grass all the way to the lake, and I have one of those. It's always been done, and it continues to be done that way. Not all of our property is cut to the lake, but a third of it. And so what is the impacts on just a piece of property that's developed with a house and a septic system?
Well, the impacts will vary from one site to another. And there's been a lot of debate in the science world about just how much of a buffer should be and how wide it should be. And the truth of the matter is it'll vary from one property to another. If you've got a property with a long slope, then you might need a larger buffer than you would have if you had a fairly flat property, that didn't have a lot of gradient toward the lake. So, and then there's variations. There's why should residential properties have a 30-meter buffer and setback when agriculture has 3 meters? I mean, where's the logic? I can't answer that. But the truth of the matter is, it varies from site to site. And 30 meters has been accepted by the province as the accepted distance for setbacks, and they won't back on that. 20 meters for buffering is what Mr. Mikowski and myself are recommending. And are they requesting that modification for the buffer? No, I don't think that they're requesting that modification. So we think it's reasonable. How much? the 20 meters should be sufficient to mitigate the surface travel of nutrients in most cases.
On that cluster there's about 25 lots. Would they have to have a separate, some kind of septic system for the whole community, or?
Actually, there's a policy in the plan that discourages communal septic systems and communal water systems. The reason for that is because whenever one is proposed and it exceeds 10,000 liters, then the municipality is going to be obligated to enter into a responsibility agreement. So we're thinking of you. And each one of these would be serviced with individual systems. The hierarchy of servicing and provincial policy actually places communal systems above individual systems, and then municipal systems on top of that as the preferred method. But when it comes to implementation, the risk level for municipalities is very high when you, as you're probably aware, when you assume responsibility.
What about existing waterfront lots that haven't been developed yet but are existing? What impacts do they have with regards to the setbacks?
Well, in terms of setbacks, the zoning bylaw that's in place now would regulate setbacks.
Right, but when this official plan passes with a 20-meter setback for development and non-disturbance of vegetation, and then we're gonna pass a zoning bylaw on top of that, which complies with the official plan. So how does that
I know.
impact
It doesn't.
existing lots now that have not been developed?
I can answer that.
Okay.
The zoning bylaw, once your official plan eventually gets approved, then you're going to be required to update your zoning bylaws. Right now, you've got 3 zoning bylaws and a village with no zoning bylaw.
Mm-hmm.
So the new zoning bylaw would have to be updated to implement the policies of the plan, like a new waterfront zones and stuff like that. So any new setbacks would be different. In this case, the water setback in Westmeath would be reduced because it's currently 30 meters, right? Or no, actually wouldn't change. If it goes, it may not change. The buffering doesn't get implemented through zoning, and so.
So it gets implemented through the building permit application process?
Well, no, it would get implemented at the lot creation process. So.
Okay, but if the lot is already there.
If it's already existing, then it's.
But has no way. There are some lots that I'm aware of that would have no way of complying to that buffer zone.
Correct.
But they're not. So would they then lose the ability to develop that lot?
No. No, existing lots of record were granted in accordance with the rules of the day, and they would still have to comply with current bylaws for zoning.
For zoning, but not the buffer.
But the buffering gets implemented at the lot creation stage. So all these concepts that we're showing are new lot creation concepts where the principles of buffering and setbacks would apply.
So that would be decided at that stage at the county level then, through the planning department, not at the local level, right?
Go ahead.
So when there's an application for a severance, it comes into the county for review, and we do a planning report and we send it to the municipality. So we look at the policies that are in place, the zoning's in place, but we also send it to you for your comments. And then you send that back, you send your comments back to us, but the county is the approval authority for severances, and we would ultimately grant the severance. And there might be a requirement for a buffer, could be through a development agreement. I think you've done some development agreements subject to a condition of a consent approval, so that's one way that would be implemented.
Okay. So we will have basically no say at the township level really on that then. That would be fair to say that?
I would not say that at all. I think you have input on.
But you, Charles, would have the final say. You could squash it, right?
I would never want to squash anything that
Now.
proposed. No.
You used that word a week ago with me. Now, come on.
The way it does work, actually, and this occasionally happens, if we have, and under our procedures, straightforward applications where there are no issues, planning issues, I can grant. And it's a good process for the public because it gets things moving and it's files that meet the planning and there's no objections from the public and no objections from the municipality. If an objection were to be rendered by a municipality on a decision of the county the county, it would go to our land division committee. So, you know, I would hand it off to a political committee to take that.
But you kind of run that too, don't you?
Oh, I never. Well, I don't. I can tell you that. We set the meetings up, but we have a committee, and they look at the information and they call it as they see it.
Okay.
Yeah.
Okay. Thank you.
If I can add, the county is the approval authority for the land severances and the subdivisions, but really, the municipality is the key player. You know, like all the conditions are implemented through the local municipality, the zoning, the agreements, everything is under the control of the local municipality.
So with that said, when we actually get to our zoning bylaws and everything, so
Right.
we'll have a lot of say when it comes to zoning, is what you're saying, and in mapping, I guess that'll all go back to Toronto or to Pembroke as far as this, this 70% that's mapped in appropriately for development. You're not saying we're going to have any control over that, are you? Like, are they not going to come back and say, hey, no, maybe they'll come back and say 80% you can't touch this? This is what I'm curious about.
Thank you. The zoning bylaw amendment is passed at the local council level. It doesn't have to go to Toronto or Pembroke or Pittsburgh for approval. It does have to align with the official plan. So if there's a provincially significant wetland identified in the official plan, the zoning bylaw has to pick that up. If there's an agriculture designation in the official plan, the zoning bylaw has to pick that up. Where you do have leeway is in zoning in the rural zones, the rural designation, what types of uses are permitted. You, within reason, not water setbacks, but you can control the side yard setbacks and the front yard setbacks. Do you want to allow semi-detached in this location or in that location? You have that power through the zoning. So there is some municipal control through the zoning, but you still have to follow the outline of the official plan.
Oh, okay, so just to be clear for everybody to understand, we would have some control on 30%. Is that fair to say that?
If that's, yeah, but that's with the agriculture and the PSWs, and Brian talked about the mineral aggregate. And I don't know if it's a 70-30 split. There's a lot of rural designation in the township. To be fair, there's a lot of rural and a lot of waterfront. So,
right. You know, if we agree to that, is there a method that we can somehow make sense of the mapping? Is there an apparatus where we can review that if we don't agree with that? Like some of the mapping, with what I've learned in the last year, leaves a lot to be desired as to what the real situation is. My fear is here that everything will be decided out of Toronto at some day, and the locals that know the land and know what the land should be used for will have very, very little say in any of this. I think that's the concern of the people.
Well, actually, Brian, I outlined one of the purposes of OPA 11 was to bring some local decision making back to the township. And we tried, and we achieved some successes, but in some other areas we didn't get success. And in terms of the mapping, the mapping for aggregates is not, by and large, pretty accurate for deposits, but we'll have issues with those. The agriculture designation, we use soil mapping for that, and that's pretty good. But there's still some ability to kind of refine that mapping. Provincially significant wetland, you don't have a lot of control over that. Those are wetlands that are important at a provincial level. The province does the mapping, and we pretty well have to go with it. And areas of natural and scientific interest. So the message is, yes, the rural area gets hit under the provincial policy statement with a lot of features that we have to protect. And I think what Brian was trying to do with OPA 11 is we can't work with those, but there are other areas of the township we can work in, the rural areas like on the water, and see what we can do with those areas to promote local interests.
Okay, thank you.
I'm just going to walk back a little bit to the setbacks. 20-meter setback is approximately 60 feet, right?
66.
66 feet. if and I'm not actually sure if I'm correct about this, but that would actually be most of the development in the modern development around our wetlands are within that. Naturally, just people have chosen to do that.
You mean shorelines?
From shorelines. There's a like 60 feet isn't very far. A lot of that would be within what people have chosen to do in the past, is what I'm thinking. So that doesn't strike me as so horrendous. You add 30 meters and can't cut the grass to that, man, I've got a real bad taste in my mouth over that. But if you're looking for a way of getting your phosphorus out because of surface and so forth, grass will do it. It doesn't have to be 10 feet tall.
Understood, yes.
You see what I mean?
I do, yes.
And so that's a concern. That's a concern of mine. People, when they develop, want the ability to make their property look nice. If they have to have their house back another 20 feet, that's not as big a concern as they have to leave a pile of junk in front of it as a buffer. You see where I'm going with that?
Yeah, I just wanted to add to that because we didn't really answer Councillor Jackson's question. The thing with the grass, from what I understand, is that the grass, people fertilize the grass, and that's the phosphorus goes into the water body, and that's an issue. And then also the grass may not be as good at stopping other surface nutrients going into the water as a vegetative buffer. That's the general theory behind this. So
I'm not entirely sure that's got good scientific basis to it, but I understand that
can
would be a concern. But grass can be. People at the cottage actually would rather water ski than fertilize their lawn, I'm quite sure. So that could be enforced. No fertilizer.
Just one little anecdotal thing. I was on a lake, Lowborough Lake, and we were on the boat, and we were with some folks, and all the lots were buffered and treed to the shoreline. And we were told by one of the people on the boat, there's one lot that you can see that's right stripped bare to the waterfront, and that's the person that in that particular municipality stands out, because they have not protected their shoreline and the buffer area the way others did. So but it's a different lake in a different area. But that was it's an interesting perspective. So.
And that sounds to me like the people themselves have a conscience to do whatever, but that could be followed through with a little of that allowed too, could it not?
It's definitely a cultural thing. It's an education item, and there's a lot of people out there that feel that these types of measures are an infringement on private property rights, and for that reason oppose them. But that's the world we live in.
What I don't understand, and this happened particularly last summer, there was a lot on the lake, and they strip cut it right to the lake, and it was a fairly steep embankment that they strip cut. And my understanding was that they were only fined a minimal amount of money, and they were not forced to put any vegetation back in place. And that was by the ministry.
That's
so
I'm
why
glad
are
you
they
brought it up.
imposing some of these things? And then on another case, you can go ahead and you can apply to build embankments, not embankments, but cement forms. You can apply, and it can be granted so that you keep obviously your property from eroding into the lake. But you can apply and do that. So there are instances where they allow it. There are incidences where it happens that they do strip it right down to the bare bones, and this was quite an embankment. And it's a minimal fine. So we go through all of this process trying to put all of these things in place, and yet they don't follow their own policy statements.
Well, actually, how can I put this? M&R have work permits for shoreline alteration. So if you alter a shoreline without a permit, they can enforce that. If you alter the land away from the shoreline, the province actually has legislation allowing municipalities to control the alteration of development along shorelines. So it's from a municipal point of view, you look at them and say, well, why are you not doing anything? From a provincial point of view, they're saying, well, we create the legislation for you to implement, and you're not implementing it. Maybe it's the municipalities should take some responsibility in controlling shoreline alteration.
But under what authority do we have? I mean, I've never seen a municipality fine or come back and say, look, you have to retree this property to where it was. You have to bring in large trees to replace what you've taken out. I've never seen that happen, and to me, if it's a provincial policy, then it should be the province. I mean, if they're going to fine them, do they not also have the authority to go ahead and say, look, you have to...
Okay, what I'm saying is the province set up legislation for municipalities to implement that, not M&R. Site alteration bylaws. Yeah, that we as part of the Muskrat Lake policies researched all the municipal tools that the province has created to allow municipalities to control or, improve water quality. And that is one of the tools available to you as a municipality, is a shoreline alteration bylaw, where if somebody alters the shoreline, like that incident, the municipality can go in and enforce the bylaw and make them to, fines and improve and restore.
So that's totally up to the municipality to do. And my understanding is we don't have that in place right now.
No, and you know what? We didn't even put it on the list. Like, I didn't even put it, it never made it to the official plan.
So basically we're saying these are the implications, that these are the restrictions that we're putting in place, but if you go ahead and do what you want, you're going to get a fine maybe from M&R, and
I think what
we're
you're
going to do
saying is
nothing.
that there's no, people are going to just do it anyway, and there's no recourse, right?
No repercussions.
Go ahead.
If, as I understand, Brian, with the OPA 11, if new lots are created and there's a development agreement registered on title that you're to maintain the vegetative buffer along the shoreline, and you go in and you cut it all down, you would be in violation then of the agreement with the municipality, and that the municipality could enforce. It's like a site plan agreement for the shoreline.
But that's not existing lots.
That's for new lots. That's for new lots.
Well, with that said, Charles, if the municipality chose not to enforce it here and there, would the higher levels of government or the M&R or the whatever come in and overrule the township and take action with these landowners?
They wouldn't be responsible for implementing your agreement. That's the townships. They might take some action that Councillor Jackson was talking about, but they wouldn't use your agreement that you weren't enforcing and come in and say, you aren't enforcing it and we're going to require you to do so. I don't think that they would do that.
But they do something, like he got a fine, right?
Yeah, whatever the other, yes, yeah.
But a small fine and carry on. Maybe it's about the money then. They just want a little money and they're okay?
I don't know.
Like, maybe?
I can't speak for their fine levels.
Okay. In this instance, it was a pre-severed lot, and the fine wouldn't be as much as for me to take my wife and grandchildren out for supper. It was a total devastation of a lot. It just unbearable to see it happen, because it all went into the muskrat, and we're trying to fix the muskrat. So, having said that, this plan needs to be very clear to us of what we have for recourse, because we are interested in enforcing that, and because we can't afford the lake to get worse because we have a couple of people that have the money to, to buck the system. That's not acceptable. It's a conscious thing. We have to have a conscience. So that would need to be really, really enforceable in this act and this system, and us understand it immensely. That'll be a request from me personally. Enough said.
Moving on here. We haven't gotten to our first item.
So I think we've done the concepts. Is that
just the rural cluster?
Rural cluster. Oh yes, this is an interesting one, Brian. Yes.
This is our rural cluster example, where you have up to 5 lots, not fronting along the public road, but accessed by a private road. Larger lots with a 100-meter vegetated buffer along the public road. So it doesn't have to be a straight road, it can be a curved road. We've just shown this for illustration purposes. This is a concept that is currently being implemented in Mississippi Mills, and I did observe another policy down in a municipality along Lake Ontario that has up to 7 lots using this type of concept. The one in Mississippi Mills, this concept is more closely reflecting the Mississippi Mills, where they are allowed to create these up to 5 lots. The biggest challenge, of course, they still have to build a road that would be suitable for emergency service vehicles access and bring hydro in, so there would be some costs. And there would be some hydrogeology involved to make sure that the groundwater is suitable and the lots are big enough. The ministry have accepted the concept, but they're saying only 3 lots. So we're looking at it going, oh geez, 3 lots is, it won't work with 3 lots, because you'll go, the cost of building the road and bringing the hydro and doing the studies, it's not gonna work. And if you can get 3 lots along the township road without having to do all that, what's the incentive, right?
Brian, would you comment on what the reasoning might be of them not wanting 5 to 3? Like, what difference would this mean to the Ontario Municipal Board whether we got 5 or 3?
Okay, I'll start. Really, when it comes down to it, obviously there's only 2 ways of creating lots: land severance or subdivision. And I'm a former county employee, and I used to work in the land division, and we'd have 10 lots come through in Griffith and Mattawatchin, and I'd have 10 files, and I'd have to write 10 planning reports, and we'd have to circulate 10 health unit letters and 10 municipal reports. And it's administratively, it's not as thorough and detailed as the subdivision process. The subdivision process is supposed to provide a higher level of review and scrutiny. It also requires the lots to be go through a land title process, an absolute title process. There's legal things that have to be done to make sure that the title is cleaner, and it's considered to be from a planner's point of view, a more appropriate level of review for development. Now, if you're so you have to draw the line in the sand somewhere between when severances can be considered and where a plan of subdivision should be considered for proper and orderly development. And 3 is the number that the province is advocating as the number that should be allowed. Whereas we're looking at rural Ontario, and in this particular example, 3 is not going to work. You need the 5. So we'll go to battle for you on that.
Brian, just wondering, you talked about Mississippi Mills now having this development, this type of development, is that correct?
Correct.
How many lots are they allotted? Do you know?
I was afraid you were going to ask. I don't know.
Okay.
I don't know.
No.
What I have found is the biggest challenge was apparently getting the hydro in some places, because there's a fee.
This would be a good idea for we've got some marginal land, you can stick it up and have
Totally.
a cluster, and they're not along the road.
You've
That's a
got
good idea.
there's all kinds of places in Whitewater where this would work.
Yeah.
Yeah.
I think it's a good idea.
It'd be great, but we don't know if it falls in that particular land. Is it in the 30% or the 70%?
There's still lots. It's a big municipality.
Yeah, it is. But our version of land use in Toronto's differs. That's a big problem, I think, in how
You're
we
correct.
feel about it and how they feel about it. Like, there's got to be some kind of solution to this that we know better up here, I think. Like, we know land. I know agricultural land versus land. I know agricultural land that could stand a severance for 2 acres, and it'd be quite all right, and it'd be good for our township. but they don't see it that way. That's the puzzle as I see it.
Well, it's funny you say that because when we were dealing with the Ministry of Agriculture and Food about the agricultural designation, we were going through issues that I had dealt with 25 years ago. It was like having to deal with the same, like obviously a younger planner than me, who's probably 25 years younger than me, and 25 years ago when I worked on the Ross official plan, I sat down with the Ag and Food representative and we negotiated where the agricultural area should be, and they've sort of been kept that way, and now they want them expanded.
Anything more on these concepts, or we thought the next little section we'd go into, which is sort of the meat of it.
I guess the only comment that I would have on this is it would be helpful, I'm sure, to prove a point that, if Mississippi Mills has 5 or 7 or whatever, that whenever you do go back to the province and say, look you've recommended 3 and we're saying we're going to stick with 5, and this is the reason, and most recently, Mississippi Mills or whoever, to know exactly what they have, might be helpful in the cause. I don't know.
It's picking your spots, and this is one we would pick to.
I think 5 is appropriate. I totally agree with you.
I like 7, and
we should have said 7 and got 5.
It's Mississippi Mills has a lot of land that's similar to ours too, so they probably have something, if it's approved already, that we definitely should look at. I agree with that. We need to go for the most, for the least, of course, for people to develop. So I think that's enough on this, so we want to move ahead.
We know we need to move forward.
Thank you. I'll just So this slide, short as it is the Ministry of Municipal Affairs and Housing draft decision, what we've classified as the positives.